is the president of T3 Technologies located in Tampa, Florida. T3 Technologies has provided mainframe computer solutions to the small and medium-sized business community since 1992. Mr. Friedman is testifying on behalf of Computer and Communications Industry Association, representing companies in the computer, internet, information technology, and telecommunications industries. Welcome.
Thank you, and good afternoon, Chairwoman Velasquez, Ranking Member Graves, and members of the Small Business Committee. First, I want to thank you for allowing me to tell my story here today. I've been a small business owner for 19 years, and it's a label that I'm very proud to wear. Let me say first that I do not disagree that intellectual property can be of great help to small businesses in commercializing their ideas. However, my recent experiences have proven to me that the current IP system is a bit out of balance and that our imbalanced intellectual property laws actually hinder innovation, disproportionately so for small businesses. This reality was recognized recently by Justice Stevens in one of his final Supreme Court opinions in Bilski versus Capos, in which he wrote, and I'm quoting, "Even if a patent is ultimately held invalid, patent holders may be able to use it to threaten litigation and to bully competitors, especially those that cannot bear the costs of a drawn-out, fact-intensive patent litigation. That can take a particular toll on small and upstart businesses." I personally hear a lot of talk about intellectual property and its importance to small business. But from where I sit, IP is really just a complicated regulatory system. The regulation of knowledge and ideas has expanded into many areas of our economy. As with any other regulation, big business figures out the best ways to navigate the system, while the little guys who don't have the high-priced legal teams at their disposal get tied up with paperwork and lawsuits, or simply eliminate innovative ideas from their plans in order to avoid such paperwork and lawsuits. My story is fairly technical and complicated, but the lesson is simple. Intellectual property can be as much a danger to small business as it is a benefit. A large firm can use the current intellectual property laws to effectively put smaller rivals that threaten its bottom line out of business. Let me first briefly explain the market I'm in. Until recently, my company built computer systems that were capable of running IBM's mainframe operating system, similar to the way Dell and HP build systems that run Windows. Although some people are unfamiliar with mainframes or may think them as relics, in reality, they power much of the world that we live in today. They are the computing power behind ATMs, healthcare records, global stock markets, the Social Security Administration, just to name a few. And 70% of the world's government and corporate data is stored on mainframes. It's estimated up to $5 trillion in business assets reside on these systems. My small company sold such mainframe systems to Fortune 500 businesses, the U.S. military, NATO, and a large number of city and county governments. I employed over 50 people who served nearly 1,000 customers in 28 countries, selling our mainframe solutions to former IBM customers who needed lower power mainframes because, quite simply, not everyone needs a Ferrari. This was a profitable niche for us, and we quickly became a go-to company for businesses that needed cost-effective mainframes. One of the reasons we got into this business was in 1999, IBM had stopped selling these smaller mainframes that we sold. With no competitors left in the field, they simply were able to scale down their larger systems and charge what we felt were monopoly rents to these smaller users. Seeing this as an opportunity for our little company, we licensed a new technology from a company called Platform Solutions, a California-based small business whose product allows less expensive hardware to run IBM's mainframe operating system. As a result, I could compete with IBM by selling much more affordable mainframe machines to my customers. Thanks to a well-known Department of Justice consent decree that lasted for decades, and it compelled IBM to license their mainframe operating system to all comers on reasonable and non-discriminatory terms. This is what permitted a small startup company like Amdahl to innovate and excel in the market in the 1980s and 1990s. The continuation of this practice was a basic assumption in our decision to develop our products. However, in 2003, IBM was released from this consent decree. Almost immediately, they began putting up obstacles to T3 and our customers who wished to license this operating system. This culminated on October 31st, 2006, when IBM publicly announced they would no longer license their patented operating system to any hardware except their own. Imagine, if you will, if Microsoft one day announced that they were building their own PCs and that Windows would only be sold on those machines. To make matters worse, they then sued my business partner and I for alleged intellectual property violations. The court process has taken 3 years, cost millions of dollars, and is still not over. To make matters worse, IBM has since purchased PSI and shelved its technology. And now, almost incredibly, in civil court, IBM hides behind intellectual property laws, claiming that they permit otherwise forbidden monopolistic behavior, essentially saying that intellectual property laws trump antitrust law.
Time is expired. Can you sum it up?
Yep,
because
absolutely.
Votes are happening right now.
Okay. Although I can afford no cure-alls, I do implore you to think beyond bumper sticker slogans and think through the whole process and the unintended consequences of these laws. And I thank you for your time.